application number 4 of 2017.
I do appear for the applicant, the firm of Asati.
Considering the written submissions on record for the applicant and the list of authorities where the applicant contends that there are 4 points of law, the legal effect of such creation, what rights remain with the transfer law of land after transfer of parcel. Parties are free to question the validity of actions of the laws, especially when they are long gone, then this additional resource of land questioning the validity of title lead to security grounds that all issues relating to the claim have been fully resolved by the High Court of Appeal. Then they had and determined that the proposed intended appeal does not involve matters of general policy.
So, this is it. Now, I may let other counsel who are here know that there are a number of matters which are in the alternative, if the court were to try this petition, then it is submitted that the court should uphold the decision of the Court of Appeal with regard to the petitioner's application for maintenance, which was exercised judiciously in dismissing the petitioner's case. Next point, the respondent submits that the petitioner has not been denied the right to be heard as alleged, the petitioner having misdirected himself as to the jurisdiction of the Supreme Court to determine the matter, and without jurisdiction, the petitioner is not properly before the court. A number of authorities are given in that regard. And the next point, the respondent submits that while the right to privacy is protected under the Constitution, the same is not absolute, as Article 35B of the Constitution recognizes the right to access to information. And next point, the respondent submits that the petitioner had not only deserted her, but was living with another lady. In addition, she submits that the 2 superior courts, in making the award of alimony, had taken into account the financial capacity of the spouses in line with Section 77 of the Marriage Act. Now, at the Supreme Court, when the matter came up for hearing, on the 19th of February 2018, the parties were asked to limit their submissions to the single issue of jurisdiction. Ms. Gadara, counsel for the respondent, chose not to address the issue frontally, but instead left it to the court. Mr. Kinyua, counsel for the appellant, on the other hand, submitted that the case was one of constitutional interpretation and no certification was required. It was counsel's contention that the issues canvassed in the pleadings revolved around the violation of Articles 25, 31, and 50 of the Constitution. However, in response to a question from the bench, Mr. Kinyua conceded that no single issue of constitutional interpretation or application had arisen or been pleaded as to be the basis for the Superior Court's decisions in the divorce cause. So these are the issues for determination. It is clear that the only issue for determination before us is whether this court has jurisdiction to entertain and determine this appeal. Towards this end, all that we need to determine is whether the appeal is one of those that rightly lie from the Court of Appeal to this court under Article 163(4)(a) of the Constitution. The said article provides, quote, appeals shall lie from the Court of Appeal to the Supreme Court as of right, in any case involving the interpretation or application of the Constitution, end of quote. This court has long settled the question of whether and when and whether an appeal lies from the Court of Appeal under Article 162.34a of the Constitution. A perusal of any of the decisions wherein the court has pronounced itself on the applicability of the said article would immediately reveal that for an appeal to lie to this court, the impugned decision must have turned on the appellate court's interpretation or application of the Constitution. We hereby revisit the pronouncement of this court in the Lawrence Ndutu case. This court was categorical that Article 163.4a must be seen, quote, to be laying down the principle that not all intended appeals lie from the Court of Appeal to the Supreme Court. Only those appeals arising from cases involving the interpretation or application of the Constitution can be entertained by the Supreme Court. It is not the mere allegation in pleadings by a party that clothes an appeal with the attributes of constitutional interpretation or application. The appeal must originate from a Court of Appeal case where issues of contestation revolved around the interpretation or application of the Constitution. Where the case to be appealed from had nothing or little to do with the interpretation or application of the Constitution, it cannot support a further appeal to the Supreme Court under the provisions of Article 163.4a. This principle was affirmed in Samuel Kamau Macharia and another against Kenya Commercial Bank, and also in Malcolm Bell against Daniel Toreti Arap Moi and another. Applying this principle to the matter before us, we find that this appeal has nothing or little to do with the interpretation or application of the Constitution, as contemplated by Article 163.4a. This is a family dispute in which the main issue of contestation has always revolved around the word of alimony. At no stage has it transmuted into a constitutional question. This finding leads to the inescapable consequence that this appeal must be struck out for want of jurisdiction, and that is the determination of the court. The appeal herein is struck out with costs. That is the decision of the court.
Much obliged.